You took the plunge, opened a case at the CCMA, but the commissioner ended up being against you. Either the commissioner was biased or the commissioner did not take into account your evidence and made a ruling against you. What can you do next? Do you have any legal rights? Hi, my name is Aslam Mullah and I am a registered attorney. That's what we're going to be covering in today's video. Let's start off with some fundamentals about taking a case on review to the Labour Court. The first important point is that you only have 6 weeks from the date of the arbitration award from the CCMA or the ruling, 6 weeks from the date you received it to take your case to the Labour Court. How do you take it to the Labour Court? You fill in a document called a notice of motion and a founding affidavit. The notice of motion has a specific format. It contains the names of the parties and the kind of outcome that you want from the CCMA. The supporting affidavit is where you lay out the grounds as to why you are taking the case to the Labour Court. The Labour Court will not easily overturn a CCMA case. They will only do so on specific grounds that you need to show in your affidavit. The Labour Court judge would be interested to know why the CCMA commissioner had made an unreasonable decision. An unreasonable decision is a decision that was not attached to the facts or the law that was relevant at the time of the CCMA. You can also make an application to the Labour Court to show why the commissioner had committed some kind of misconduct against you. In other words, they did not conduct a fair process when they had the CCMA hearing. They were biased, they didn't give you a fair opportunity to lead your case, they improperly favored the other side, etc., etc. They did not consider your evidence when they made their ruling. These are things that you can challenge at the Labour Court. Once you complete that document, you then serve and file that document to all of the parties. It's very important to note that this is an affidavit, which means that it must be commissioned by a commissioner of oaths. After you serve and file that document, the CCMA will release a recording of the CCMA proceedings. That recording needs to be transcribed and it then needs to be served and filed on all the parties. The opponent in your Labour Court case will then have an opportunity to oppose your application. They will file their own affidavit in response to your affidavit. In regards to the transcription of the CCMA recording, you have 60 days to make sure this is done. Our firm can assist you with that process. Once the opponent responds to your application papers, you may or may not do a replying affidavit to their response. After that process is done, the parties then need to do some preliminary court work. For instance, a practice note, heads of argument, indexing and pagination of court papers, etc., etc. On the day of your hearing, the judge's clerk will call your case number out. It will be your opportunity to speak and present your case. The opponent will then get their chance to speak and then the judge will make their ruling. As you can see, this is a fairly legal process and it requires knowledge of the legal processes of the Labour Court. I would highly suggest that you utilize the services of a specialist labour lawyer to get these documents prepared and your case argued in court. If you need help in your situation, whether that's deciding whether or not to take the case further, or to prepare the court papers, or even to appear at the Labour Court, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best, and I'll speak to you soon.